Good morning. Thank you for coming. Today we're talking about the Americans with Disabilities Act. And so the first thing about the Americans with Disabilities Act is that it was passed in 1999 and signed into law by President George W. Bush. The Americans with Disabilities Act is designed to combat discrimination with people with disabilities in the United States. So quick facts is that it was originally introduced into Congress by U.S. Senator Tom Harkin of Iowa. In the House, it was passed with a vote of 377 to 28, and in the Senate, a 91-6. So very strong bipartisan support on both sides of the aisle. This is President George W. Bush signing the bill into law. Inside the ADA, the ADA defines a disabled person as a person with a disability, with a mental or physical impairment which substantially limits one or major life activities. Now, when we talk about the court and how the court deals with this issue, that definition is going to be critical. There are 5 sections to the Americans with Disabilities Act. They include the employment section, public service section, public accommodation section, telecommunications, and miscellaneous. The employment section makes it illegal for an employer to discriminate against an employee or job applicant for having a physical or mental disability. The public services section makes it illegal for a state or local government to deny access to public services and activities because of that person's disability. The public accommodation section requires businesses, large and small, to provide accessibility to persons with disabilities. The telecommunication section requires telecommunication companies to make communication devices accessible to persons with disabilities. So if you've ever seen on a business card, you see that TYY or TDD number at the bottom, that's why it's there. The miscellaneous section just contains other technical details and things of that nature. When the bill was being debated, these were some of the major supporters. Reverend Jesse Jackson, and we all know him, he's one of the major figures in politics, in civil rights politics. He said this: Americans with Disabilities Act does not receive protection of the Civil Rights Act of 1964. The ADA would right this wrong, and he's exactly right. The Civil Rights Act did not contain any provisions for disabled persons. Mr. Rolfe from the Council of Leadership Conference on Civil Rights said this: the ADA would assure disabled persons are judged as individuals on their merit by eliminating biases in the selection procedure. So now we come to some of the opponents, and we all recognize the U.S. Chamber of Commerce, one of the biggest, probably the biggest group of employment lobby in the United States. They said this: the focus of the ADA should be on opening up opportunities for the disabled, not one in posting unreasonable and unworkable demands on the business community. Now, there's a good point there, because if you're a small business, at least back in the 80s, if you're a small business, it will cost a lot of money to have the kind of things that we have today, where you can actually press the button and the door opens up, or working elevators, or the kind of metal bars in the stalls where a person who's in a wheelchair can actually get up and get in. So it costs a lot of money to implement services for disabled persons. So there is concern there. Wayne Smith, representing the United Bus Owners of America, made this statement before the committee in the Senate during markup. Now, markup is a point in the consideration of a bill in Congress where members are actually, where separate committees are making changes and adjustments to a piece of legislation that they're considering. So he made this statement. At stake, Mr. Chairman, is the question of whether this committee is ready to jeopardize the most widespread, most affordable means of transportation now available to American citizens to establish a worthy but limited goal of full accessibility for a small segment of the nation's population. This sounds kind of hard. So now we get to the courts. And this is where that definition becomes very important. Sutton v. United Airlines. Here's the story. Miss Sutton and her sister had myopia, it's a disease which affects the eyes. They wanted to be commercial pilots for United Airlines. And United Airlines are one of the major, one of the biggest airline companies in the United States. They wore glasses which actually corrected their vision to the proper, what you would actually need to fly a plane. Unfortunately, during the interview process, when they had their eyes checked by United, they were told that they were not going to be considered for employment because they needed to have 20/20 vision uncorrected by glasses. Now, when they tried to file suit, the case was dismissed, and Justice O'Connor, writing for the court, said corrective and other mitigating measures should be considered when determining if an individual is disabled. So, in fact, what she's saying is that if you have a disability, it has to be determined with the corrected measures, such as glasses. So if you have high blood pressure, which we'll see in the next case, if it can be corrected with aspirin or any type of medication given by your doctor, you don't have a disability, at least not for protection under the ADA. And that's exactly what happened in Murphy v. United Parcel Service. Mr. Murphy, now, United Parcel Service is one of those trucking companies that they transport all of those goods across the, those big trucks that you see going down the freeway every day. Mr. Murphy was a mechanic, and he wanted to be a driver. The Department of Transportation requires that you have a certain amount of blood pressure because you were driving those big old trucks and things of that nature. So he was not considered for employment anymore. So he filed suit, and his case was dismissed. Same reason. The court held when determining whether one is disabled under the ADA must be made in light of available mitigating circumstances. So it's the same thing that we saw in Sutton. If your disability can be corrected by a mitigating measure, whether it's medication, whether it's glasses, you don't have a disability, at least not for the protection of, not under the protection of the ADA. But that's not the end of the story. In 2008, Congress passed the ADA Amendments Act. It was designed to overturn a number of cases that actually limited the protections that the ADA was originally designed for. I draw your attention to subsection 4E. It states this: the determination of whether an impairment substantially limits a major life activity shall not be made with regards to effective mitigating measures. So this effectively overturns Sutton and Murphy. So Congress is saying, well, we don't want you to consider whether someone's disability is in its corrected state. We want you to consider it when it's not in its corrected state. This is George Miller. This is during floor consideration of the, when the bill made it to the floor for a final vote. He said this: we intended that the ADA Amendments Act would reduce the depth of analysis related to the severity and limitations of impairments and return to the focus to where it should be. The question of whether or not discrimination based upon a disability actually occurred. It is time to restore the original intent of the ADA and ensure that tens of millions of Americans with disabilities who want to work, attend school, and fully participate in our communities will have the chance to do so. U.S. Chamber of Commerce. They said, we thank Congress for their bipartisan leadership and quick action on this legislation, which will help ensure that disabled Americans will have a fair chance to excel in the workplace. Now, if you notice, when I showed you the first couple of slides, their statement was completely different. So how in the world in 20 years did they do a complete 180? Well, there's two reasons for this. Well, at least what I suspect. One, if you remember the vote, 377 in the House and 91 in the Senate, it was very popular then. And by this time, the Democrats had already taken back control of Congress, so it was going to pass. Secondly, when they first introduced this bill, the ADA Amendments Act, it was called the ADA Restoration Act. And basically what it did was it very much broadened the definition of a disabled person. So you could stump your toe and you could go and say, I'm disabled. So that's basically what it said. So the U.S. Chamber of Commerce said, you know what? Why don't we just sit down and work with the people in the disability and civil rights community and get a bill that is going to be much better and is going to not broaden the definition too much, because it's going to pass anyway. So that's the story on the ADA Amendments Act, and we see the effects of it throughout this country. When you get up in the morning, you go to work, you see the lines, the blue lines and the signs that has a little disabled sign on them. You go to school, there's programs and all types of services that schools like Eastern and like high schools offer for people who have disabilities. So I would like to thank you for listening to me, and I would be more than happy to address any questions.
What kind of programs does Eastern offer?
Eastern has the DRC, the Office of Disability Relations, and things like that. So if you have a disability, you can actually go to that office, and they have staffs in there that will actually work with you and your professors to get you kind of services such as more time on testing, accessibility to your wheelchair, just a variety of different services that school offers. Yes, sir.
Since they passed reform, is there any controversy left, or are most of the parties happy with what's going on today?
We don't know. The fact is that like any law, like we're actually seeing today, this can always go back to the courts for something else. I mean, there could be accessibility issues that are disabled that are in the court. There are laws that have been on the books for 30, 20 years, like the Voting Rights Act. The Supreme Court came back 2 or 3 years ago saying that the Section 205 of the Voting Rights Act is still constitutional. So it can always go back to the courts. Yes, ma'am.
I kind of have two questions. First of all, do they take safety into consideration, like with the pilots that were having corrective lenses?
Mm-hmm.
I would think that might be a little bit of a detriment to being a pilot, because you really do need to have good vision. I know my husband has spare glasses in all of our cars because if he breaks his glasses, he can't see. So even to drive, it's a safety concern. Same thing with the guy with high blood pressure. You know, can he really be safe driving the truck?
Well, his doctor during at the lower court actually testified, saying that when he took medication, that he functioned just like any other person. So on the medication, he probably Professor Morozki probably.
I know you have another question, but could you address, just because you're qualified under the ADA doesn't mean you're going to get the relief you want. You go to the issue of, I don't want a blind pilot either.
Right.
Okay, I'm funny that way. But can you address the idea of reasonable accommodations and how they may have to make an adjustment to the disability, but it only has to be reasonable. They have to perform the job.
Yeah, that's basically it.
Because I just said what he was supposed to say.
Other questions?
Sorry, and my second question was just about mental disabilities. Are things like severe depression or schizophrenia, are they considered disabilities that an employer would need to somehow accommodate?
I'm not really sure. I know epilepsy will qualify as a disability, but if Sutton and Murphy were allowed to stand, they wouldn't actually be. You wouldn't actually have a disability in this corrected state. But Congress actually, it probably is in there, because when Congress originally, when they actually passed the bill, they actually had a big old, like almost 2 paragraphs of what they actually meant by major life activities and what they meant by protected disabilities. So, other questions?
In some cases, is it really hard to prove that a person, that you were turned down for employment because of a disability? And I guess the question I should have asked first was, how much information, if you have a disability, how much information do you have to give at a job interview? You know,
Well,
how much information?
First off, you're not required to. You're not required to tell your employer that you have a disability. You're not required to do that. And two, you basically want to have like basic paperwork, maybe medical history or information from a doctor, a diagnosis, something like that, saying that this is what the disability is, and this is how it affects them, and things like that. And any licensed doctor or psychologist, if you have like learning disabilities.
But is it legal for an employer to ask a person, do they
I
have
don't
a
believe so.
disability?
If it's job related.
Okay.
Other questions? Thank you so much. I appreciate it.